No, I'm not. I'm not the only driver on the policy. It's a few of us. But I just want the
I'm
current
not.
the
I'm not the
current
only driver on the policy.
the
It's
current
a
policy
few
has
of us.
the breakdown the breakdown coverage. And so I want to keep that in place for the newer cars. I just
Of
want a
course.
quote. All right, and you got that. And it's for Florida, right? So
Yes, correct.
okay, all right, sir. Well, yeah, it would be. But you got my name down there. Everything. You got Angelina Walker and all that. You got my name down, right?
Yes, I do.
Okay. Just give me a minute. But like I said, I need a quote with that in there, and I think pretty much you got everything I filled out, right?
Yeah. The only thing I needed was the other drivers like that. When you call me back, I already have everything
The
set up
other
for you.
drivers. Okay. All right, not a problem. I'll give you all that. Okay. I'll give you that. Joel, right?
Yes.
I'll give you a call back. Thank you.
All right, not a problem.
Goodbye.
Bye-bye.
Oh my God, I'm so goddamn hot. So listen, it, can y'all hear me? Oh my gosh, y'all. When I tell you everything that can go wrong is going wrong, oh Lord have mercy. I'm sorry I got that call. Because I want to jump right into it. I ain't want to do no introduction or whatever. I want to jump right into it. Listen, yeah, please that like me. Y'all can hear me? Oh yeah, y'all can hear me because I heard myself on the other thing. It's so goddamn hot. Oh god damn. Hold on. Yeah. I'm sending y'all of America. Yeah.
Advanced retail.
Yeah.
Child, what was talking about? And this requires traveling. And I was like, what you mean, like traveling? Like within Jacksonville or outside of Jacksonville? And I'm like, no, Tallahassee, Gainesville, Clearwater. I'm like, what?
Oh, what project is it? What you moving? What you pushing? What is? Did they tell you what it is?
No, I ain't get that far.
Oh, okay. Well,
Like,
um,
no Tallahassee, no Clearwater, no crazy.
right. Well, I got one that you can work that's due by the 12th if you want to work that for me. I'll send you the all the particular about the projects. It's jewelry and sunglasses. It's not that hard. You just gotta
Is it,
put
is it at a, is it at a Target?
yeah, it's at a Target. You can push that. It's in
I,
32246. All right, I'll send it to you because I need to get it done by this week.
got you.
All right, thank you. Bye. Oh Lord. Oh, who is this? Oh Lord. Oh my God, y'all. Listen. So listen. And I can't be holding on no phones and shit like that. So y'all can hear me. Yes, I am dying. So it seems like, oh Lord, somebody gonna call me. Oh, that's he can call me when I get there. So listen, I think nobody that man don't want the job because of the size and the complexity of the goddamn the AC unit or whatever. I don't know why nobody don't want that money or what have. I don't know what the fuck is going on. And it ain't no and it ain't no black people or whatever. It's white man. And I because when he wasn't specific about the unit and all of that I needed and whatever, he was just gonna give me the bill or the pan and all that bullshit. I don't know about no pan. I'm about to die. I'm about to die. I can't deal like this. I went and found I had a personal um, ice maker that you could just plug up in your room and stuff. But I got my refrigerator, all that type of stuff. I went and found dug that bitch out. And let me tell you something. I made that ice and shit, and the ice melted quickly. And I had a cold soda out the refrigerator on top of it. Like what the fuck? But I have to be over here, but just to come over here to do this right now in my setup and my working on stuff. I got my little makeshift setup over here and whatever. I ain't been over there. On the other side, like 2.5. Got what since January 2020, like 2.5 years. Job. Honey, y'all be all in my goddamn personal business. I don't give a fuck. I don't give a fuck. I really don't. Oh man. But listen, we got to do better with our we're keeping up what we're keeping up because over here we keep our shit together over here. So it is for entry number 247 is what is due for the ninth. That is, hold on real quick. What we're looking for today. We are looking for a response from the government with regards to a motion to compel for um for Jim Derogatis. That is what we're looking for this issue with Jim Derogatis. That is not for the videos, or any of that. Okay, I told y'all Judge Lynn Webber was gonna drive me fucking crazy. I knew that he was gonna handle his shit like this. I knew it all over the goddamn place. Nothing specific in the system. Nothing structured. That's just driving me crazy. So with the videos, the prosecution, they could respond at any time unless they handled that on the call. Well, I don't think they probably handled it on the call because we would have known that there was some issues with the videos. This is a new issue that came up via a brief. So now we don't know how long the prosecution is going to take to respond. Hold on, y'all. Um, I'm gonna get to the reader. I am. Just give me a minute. I'm trying to get all this shit together, baby. I am every motherfucking woman. God damn. Okay. So let me see. Um, Response. That's expert witness. Okay. Motion. That's that. When they talking about them damn tapes, the tapes came out on the 8th. Okay, the chain. Okay, so that came out on the 8th. This is the ninth. So ain't no big deal or whatever. So we waiting on the prosecution's. Um, we're either gonna wait on the prosecution's time to respond, or maybe the judge will get off his ass and put in there and give us a hard date in which they need to respond by. Yeah, this is how my life goes. Really, really, really. Yeah, I'm the one supposed to be disabled and I'm getting stamps, but yet I'm moving shit. I don't know how this works out, but whatever it is, right? So so that's what we're waiting for. We're waiting for the judge to either tell us when we're going to get when the prosecution should respond with regards to those tapes because that's a hot item, or the government will go ahead and respond. All right. Right now, the ninth, we're waiting for the government to respond with regards to Jim Derogatis. All right. So make sure we get that all together. Please make sure we get it together. My life be off the chain, baby. Ooh, ooh. Okay. So before I get into this little reading, I don't know how many pages it is. Let me see. It's 11 pages. I swear this goddamn attorney love to do 11 pages. Maybe okay, maybe that could be the actual required procedure. So let me not knock them. So we're gonna put that up there. So just to go over a couple things, in the beginning I like to give a little whatever, a little intro. So what I was trying to explain last night. Oh Lord, let me shout y'all out. Jesus, let me do my chat call. Hey Zoe, you was first. Woo! Red Bunny. Don't give him none of that honey. Hey Gigi, what's good with it? What's good with it? Sir Miguel, back in the building. Hey Leslie Jennings, what's good? What's good? Peace in this puzzle. Hey Regina White. Hey. Hey, no, Gigi, I have a little portable air conditioner, right? And when I tell you that shit wasn't because I had an issue a while ago on the other side. I have a portable air conditioner. That shit ain't do shit. And you had to pour water in it and all of that. I ain't lying. You know, I'll take a picture of it and upload it for you. Yeah. But and so I wanted to pull that out, but I don't know if that would help. But I'm gonna tell you, I have gotten a sunburn. This by being hot. But what I wanted to recap a little, and I'm sorry I fell asleep last night. Shit, I don't know what happened. But I, appreciate everybody that came through, all the new people that be falling out the bushes, all the old people that be falling out the bushes, people feeling comfortable to come in the chat and things of that nature, no matter what side you're on, who you support. You got to know I appreciate you and I love you for your participation. What is thing? All right, so listen. So this is what I was trying to illustrate last night, and I'm hopefully I'm putting it in a better way because a lot of times people conflate how they feel about the law and how they think it should work, and they contrast that with how the law works and what it's actually about. Okay, so evidence. Okay, I'm just gonna give a little briefing. Evidence is what comes out of discovery. If something is discoverable, it's sent up there and discovered. It goes through a process of being authenticated or what have you, either before or during or after, but well, either before or during the trial process, right? They do that by offering it up and seeing if it's admissible. It's only going to be admissible if it's relevant, relatable, and reliable to the charge. To the charge. You know what the charges are and the elements because you simply just can pull out the indictment. Okay? You can just simply pull out the indictment and it'll tell you. Now, with those what I would call external factors, the emails, the flipping of the witness and all of that, whatever, that's what I would call external factors. Factors that can affect the outcome of a trial. Okay? It doesn't mean that it's relevant, relatable, reliable to the charges, what he's been charged with. Okay? So I was trying to illustrate, just like she could say, if but for Larry's involvement with Azriel, she wouldn't have flipped, or but for Tasha K and text the the emails, whatever, she wouldn't have flipped. And keep in mind, you got to prove that. You got to prove that's the reason why she flipped. And if the case involved questioning people, or as to the reason why he flipped, then okay, then that part would be in the case, right? That would have required that Canic, upon cross examination, which they asked, like, well, did you meet with the state's attorney to prepare for your testimony and all those line of questions? If the judge would allow it, and depending on, because at that case, that part, what made her flip and all this, whatever, that would have to be a defense that would have been approved by the judge. You remember? That's why they go through the process of the emotion and limiting. Okay? So that's when they're shutting down defenses or shutting down parts of the prosecution case. So if the judge say, yeah, that would prove something, just pretty much how the judge was you know on the fence about that whole extortion thing. She was like, yeah, if you got somebody that, there's no direct evidence, but if you got somebody with direct evidence, which, that could be a testimony, the testimony can be direct evidence, then yeah, she would allow it as a part of their defense. Okay? So just say the judge allowed it, whatever. That would be the process. He would, mechanic would have to ask her, well, why did you flip? Well, why did you do this or whatever? All of that would be building reasonable doubt or strategy. But it still has nothing to do with why he was charged, what he was charged for, and what he was indicted for, and what he was found guilty of. Still don't have anything to do with that. And they're trying to mesh this thing into one. And like I was saying, just like she said, but for Larry's involvement, Azrael would have never taken a stand and, remove her from the case. And then what do you have? You have others, and you have, the charges with regards to her not, not there. But she was already included in the indictment. Charges with regards to her, she was already included in the indictment. That was before she allegedly flipped. So that's showing you that one thing don't have anything to do with the other. It may have, her involvement on the stand may have affected the outcome. And I say may have, because I can't predict, the future on something that has already happened. It's already happened, so there's no need for a prediction, right? But what I'm saying is, she, without, so it's like putting two things to one. It's like there, and I understand. Trust me, I understand, because that's why I say, to show my understanding, I went even further. I said, well, if Azrael was never involved with R. Kelly in the first place, she wouldn't have showed up in the charges with regards to her, wouldn't have been in the indictment, and two, there would be no need for her to be flipped. And three, I can go a little further, the evidence that subsequently came after she flipped, the storage and all the testimonies, and telling where the bones are buried or whatever, wouldn't have never come about. So I can go down the line of, but if she wouldn't have, but if she wouldn't have, I have one for that too. But even what I'm talking about has no bearings on his charges. That's something totally different. Has no bearings on it. He would have been charged. He was recharged regardless for acts. That's what we're talking about. He would have been charged regardless. Getting people to testify and all of that, and even coming up with physical evidence and all of that, that's a plus. And that only affects the outcome of the case. So to be a little bit more graphic, when you look at his indictment, and you go down the line, all of the indictment and the investigation is with regards to his penis. No Tasha K emails, involvement, or whatever about no visitation list, no calls, or whatever is for, has anything to do with his penis and where it was on said date and time. Allegedly. Heard what they said. Lord, I hear thunder. Please let rain come follow it. So that's all I was trying to get people to understand. And I definitely understand what you're saying about the flipping part and the Larry involvement part and all of that. I understand that. I wholeheartedly understand it. I'm just telling you that there is a legal process and you have it wrong. And I'm not saying only you have it wrong. It's been confirmed you have it wrong based on the filings that's coming out. And that too of the defense. There's nowhere in their paperwork they're saying, but for Larry's involvement, the witnesses wouldn't have flipped. There'd be a damn fool to put that in there. Who would put that in there? Do you want do you want your law license to be in question? That's why you never seen anything about a setup, a takedown, and all of that shit. That's street shit. That's YouTube street shit. Ain't no lawyer in America unless they motherfucking, And I'm gonna tell you something. I ain't do particularly good on the motherfucking LSAP. I mean, I barely made it, and I took my ass to a state where the goddamn uh, uh, passing and shit is low and shit like that. I ain't stupid. I barely made it, but I made it. I passed it. But what I'm saying is that so if that was the case, J Bo went as far as saying whatever she said in those motions. She had no hesitation on putting that part in. She would have no hesitation. She could have disguised it under witness tampering for real. Why she didn't put it in as witness tampering? So we got to separate how you feel and how you think the law should be and what it's not, and all of that is not a legal argument. It is an emotional argument. It may be a common sense argument, but it's not a legal argument. So that is what I'm trying to, convey. Oh, wait a minute. Hold on. I'm sorry. I got another issue because somebody want to play with me. Hold on. Let me take this down because I don't want nothing to come up that y'all don't need to see. Hold on. Hold on, y'all. Okay, I got a matter of a law right quick. Just 1 minute, okay? Hold on. Child, shit, I'm busy, but give me just 1 minute. It ain't gonna take me about a couple minutes. Hold on. Okay, they need to know it. Don't you ever send me nothing uh telling me what a code does not goddamn mean. Are you serious? You trying to interpret the motherfucking statute. That's your interpretation. My interpretation came with motherfucking um evidence and proof with as well as a goddamn reference to know that to show you what the fuck you talking about is incorrect. Shit. The fuck it is you talking about? What is this? I mean, you got to be out your goddamn mind. You really do. Um, no, wait a minute. Okay. So that's the only thing I want to stress. So what was discovered with regards to the BOP, whatever, even if it, was something that really violates his rights, it's still, I mean, you still have to ask yourself, is it substantive to his charges? Is it material to his charges? Is it probable to his unprobable to his charges? Probative to his charges? Like no. So therefore, it has nothing to do with his charges, not at all. You're talking about how it would affected, how it could have affected the outcome of the case. Two different things. Okay, so let me read this real quick, and we can get into something. I got an awfully busy day. I want to tell me some bullshit. You crazy, baby? You a newbie? Are you fucking kidding me? You a fucking newbie? I fired off on her ass real quick. Let me take that down. You crazy? I ain't take that long. Better get your shit together, lady. It's hot and I'm crazy. I'm crazy as hell. Hold on. Tell me about that. Tell me what it don't constitute. Got me fucked up. Does constitute that. Girl, it's busy the goddamn day. Whew, okay, let me read this. Where is my remote? Okay. It says, is it up there? Okay, it says government motion to exclude testimony from defendant Kelly's proposed expert. Is that the right one? No, that ain't the right one, is it? Hold on. Is that 274? Yeah. Okay, so all right, so it looks like the government is trying to exclude testimony from one of the defense's expert witnesses. Wow, this is crazy. We didn't see none of this in the New York case, right? Because they had those five little witnesses, and you know, I don't know if they brought in any expert, but we're gonna see. Let's see what it says. Okay. Defendant Robert Kelly informed the court that he is not planning to raise mental defect under Rule 12.2. Yet Kelly now seeks to call an expert witness at trial to testify about his intellectual disabilities. Remember when I did that goddamn RSK uh thing exercise, looking for defenses and stuff, and this was one of them that I put in to go along with an exculpatory defense with regard to his deficiencies with his intellect, his reasoning, and mental and all of that. This lady, I'm trying to tell you, y'all leave that goddamn lady alone. Leave that defense team alone. Leave them people goddamn alone. Y'all sending them people shit that has no motherfucking bearing with regards to their charges, whatever. They wasting their motherfucking time chasing ghosts and shit. Oh, it's fun I said ghost because Larry's have the ghost mask. Oh, shit. What I mean, let me change it. Because I don't want nobody to think, oh, no, I ain't favoring no motherfucking body. It is what it is. I got nothing to do with that. Okay? I just tell the truth about the shit and present the facts as it's presented to me. But yeah, let's read. Let's see where we're going with this. Okay, reference. It says Kelly has not provided proper notice under Rule 12.2, and even if Kelly provided proper notice, the proper expert testimony is inadmissible. The government requests that the court exclude testimony from Kelly's proposed expert. Y'all, this is just what I say. All of this now, right now, it looks like that it is being caught up in with regards to timely notification and maybe timely filing, right? The defense already knows this. They know what's supposed to be filed and all of that because you got to do it for a certain time, prior to the trial. I think that they're doing this as a part of the overall, you know, strategy to get this out in the media because they know this is going to be denied, probably. And if so, they can say, look, y'all, they won't even let us introduce information about his intellectual disabilities. Y'all ain't going to understand that there are timely filings and timely notifications and shit like that, and to which you have to let the other side know that you intend to call a certain witness, expert witness, or whatever. Y'all ain't going to know that. All y'all seeing is the miscarriage of justice and the unfairness with regards to R. Kelly. That's the only thing y'all gonna see. This is pretty good. This is some good shit here. Let's go. Background. On July 28, 2022, Kelly submitted a letter pursuant to Federal Rules of Criminal Procedure 16B1C, notifying the government of his intent to present at trial testimony from Dr. Daniel Martell regarding Kelly's significant impairments in academic function, illiteracy, below average cognitive abilities, and IQ, which was measured at a 79. Ooh. The Rule 16 letter further indicated that Dr. Martell would testify regarding the implications of Mr. Kelly's intellectual disabilities. According to Kelly's disclosure letter, Dr. Martell conducted intelligence testing on Kelly on May 19th and May 20th, 2022. Kelly also provided the government with 2 mitigation reports prepared by other individuals that refer to a forensic neuropsychological examination report by Dr. Martell dated June 6, 2022. The government has not received a copy of Dr. Martell's June 6, 2022 report of any of the report from Dr. Martell. 2. Kelly has failed to comply with the notice requirements of Rule 12.2. Boom! I just told you. The notice requirements. I'm trying to tell you. I'm on my goddamn free job today, baby. I told you there's a notice requirement that he has to do this. Honey, I should get paid $1 million for this goddamn free ass shit. Let's see. Okay, let me repeat that. Kelly has failed to comply with the notice requirements of Rule 12.2, and this court should bar the expert from testifying. Federal Rule of Criminal Procedure 12.2 sets out stringent notice requirements where, as here, a defendant seeks to introduce expert evidence relating to a mental condition bearing on the issue of guilt. If a defendant intends to introduce expert evidence relating to a mental disease or defect or any other mental condition of the defendant bearing on either one, the issue of guilt, or two, the issue of punishment in a capital case, the defendant must, within the time provided for filing a pretrial motion or at a later time the court sets, notify an attorney for the government in writing of this intention and file a copy of the notice with the clerk, which is a more fancy way and comprehensive way to express what I just said. Federal Rules of Criminal Procedure 12.2b. Upon the defendant's failure to give notice under Rule 12.2b, the court may exclude any expert evidence from the defendant on the issue of defendant's mental disease, mental defect, or any other mental condition bearing on the defendant's guilt. Federal Rule of Criminal Procedure 12.2d.1. Kelly's counsel entered her appearance in this case on February 18, 2022, and since that time has filed multiple pretrial motions, including a motion to dismiss and a motion to sever. Reference. The deadline to file motion in limine was June 13, 2022. Reference. Kelly did not file any motions related to his alleged mental defect. In his response to the government's motion in limine to preclude introduction of evidence or argument related to a mental defect defense, reference, Kelly stated that he is not planning to raise mental defect under Rule 12.2. Reference. Then, less than 3 weeks before the scheduled trial date, Kelly for the first time provided the Rule 16 notice about his intention to present expert testimony concerning his mental conditions. Rule 16 in this case is talking about pretrial motion. The Rule 16 letter states that Dr. Martell will testify regarding the implications of Mr. Kelly's intellectual disabilities. There is no question, based on the description, that Dr. Martell will seek to testify as to a mental condition bearing on the issue of Kelly's guilt. Kelly has also failed to file a notice with the clerk of his intention to provide expert testimony as Rule 12.2 requires him to do. So, check this out. So, what they're saying, if they would have put this, the defense on a motion to limine, right, to get it included or what have you, that is a defense, right? They're trying to get a defense in. And as you see, it says on the issue of Kelly's guilt, meaning he's going to be expected to testify why one with his reasoning, his intellect deficiencies may have, committed this crime. That's the only way I can say it. But just because somebody commit a crime, there is factors that most time make that happen. Sometimes somebody with intent, hey, they meant to do it. They know what they was doing. They knew the outcome. If you lack the mental capacity to make such decisions as to right or wrong, you may commit a crime. Okay? Let's see. Where am I? Further, Kelly's Rule 16 letter directly conflicts with his assertion that he will not raise any mental defect defense under Rule 12.2, undermining any possible fair notice the letter may serve under the rule. Accordingly, and on this basis alone, the court should exclude the proposed testimony of Dr. Martell pursuant to Rule 12.2. Rule 12.2b further provides that the court may, for good cause, allow the defendant to file the notice late, grant the parties additional trial preparation time, or provide other appropriate relief. So we got some semblance of relief in this motion, right? This is in the alternative if the judge allows Dr. Martell's testimony. That means that the prosecution get extra time. They can prepare for Dr. Martell's testimony. Okay. It says Federal Rules of Criminal Procedure 12.2b. Kelly has made no effort to establish good cause, and without any such showing, it must be assumed that none exists here. The objective of Rule 12.2 is to give the government time to prepare to meet the issue, which will usually require reliance upon expert testimony. Rule 12.2 Advisory Committee notes the government is also entitled to request that the defendant be examined under 18 U.S.C. Section 4242 after receiving such notice. The significance of a Rule 12.2 mental defect notice is such that failure to give timely notice, okay, commonly results in a continuance of the trial and a corresponding delay in the administration of justice, which can also be another strategy. Maybe they're trying to get a delay. Here, the government is prejudiced by not being able to take the steps Rule 12.2 allow to examine Kelly's mental defect claim and any anticipated testimony of his expert witness. The government requests that the court bar Kelly's expert witness on the basis of untimely notice alone. 3. The legal standard. The admission of expert testimony is governed by the Federal Rules of Evidence 702 and the framework established by the Supreme Court in Daubert versus Merrill Dow Pharmaceuticals, Inc. Case law. The Seventh Circuit of 2009 stated that this court acts as a gatekeeper and has a special obligation to ensure that all expert evidence is both relevant and reliable. Where you heard that from? Case law. The first requirement of Rule 702 is that the expert's knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. Federal Rules of Evidence 702A. Expert testimony helps the trier of fact if it is relevant. It is not within the jury's common knowledge and experience, and the testimony will not you uh you how to pronounce the word usurp 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 I forget how to pronounce that word. The jury's role of evaluating a witness's credibility, which that word means like supersedes the. I don't know how to pronounce it, but I know what it means. Supersedes the jury's duty, you know, overcome the jury's duty in establishing some witness's credibility. Case law. And it says when cross examination, argument, and jury instructions are sufficient to allow the jury to assess the evidence, expert evidence is unhelpful and improper. Case law. The 11th Circuit in 2004 stated that the remainder of Rule 702, no, that's not it, I'm sorry, scratch that. The remainder of Rule 702 requires that expert testimony be based on sufficient facts or data, that it be the product of reliable principles and methods, and that the expert reliably, apply the principles and methods to the facts of the case. Federal Rules of Evidence 702B slash dash D. Kelly has the burden of establishing that his proposed expert evidence is admissible. Case law. And in determining such admissibility, this court has broad discretion. Reference. Even if proposed expert testimony is admissible under Rule 702, the court may exclude it under Federal Rule of Evidence 403 if it's probative. I'm all fucked up today. Probative, if its probative value is substantially outweighed by a danger of unfair prejudice, confusing the issues, misleading the jury, or wasting time, right? So those are always the issues in which a either side seeks to get evidence to be inadmissible, right? Those are the most common excuses. As the Supreme Court recognized in Daubert, expert evidence can be both powerful and quite misleading because of the difficulty in evaluating it, and therefore the judge in weighing possible prejudice against probative force, I'm sorry, ex, oh Lord, exercises more control over experts than over lay witnesses. Reference. Argument. A. The proposed testimony is inadmissible under Rule 702. Kelly's notice provides that Dr. Martell will testify about Kelly's significant impairments in academic function, his illiteracy, his below average cognitive abilities, and IQ, which is measured at 979, and the implications of Kelly's intellectual disabilities. Dr. Martell's testimony should be excluded. However, because it is not relevant, it is not helpful to the jury's understanding of the issues in the case, and it is unduly confusing and prejudicial, which is a strong point. Kelly has not shown how this testimony is relevant to the case. And this actually, they can come back and say is relevant to his defense, right? But it's now untimely because it should have been on one of those motion in limine, right? It would be a Rule 12 issue. Kelly has not raised any insanity defense, and as a result, mental disease or defect does not otherwise constitute a defense. It doesn't constitute a defense, right? But it is a part of a strategy. And hold on. It doesn't constitute a defense, but it can be used as one. All right. What I'm saying is because it could be exculpatory, just like when when they put in the mistake of fact, mistake of age. That's an exculpatory defense. It either justifies or excuses one's actions in a criminal proceeding. Okay. It does not say that a person is 100% guilty, but it mitigates one's guilt. It mitigates one's guilt to the fact that if presented to a jury, they could look at that and say, hey, I can find this guy not guilty because he only committed those crimes because of his lack of reasoning. Okay. So, and that's different than an insanity plea. I explained that a couple lives ago. That's different. Let's see, that's 18 USC section 17A. Dr. Martell's testimony is also not relevant because, as described thus far, it does not negate the mens rea, right? And I always talk to y'all about mens rea. That is the mental, the intent, the reasoning, the intellect, and all of that, the mens rea of a specific intent crime. The indictment charges Kelly with enticement of a minor to engage in sexually explicit conduct for the purpose of producing a visual depiction. 18 U.S.C. Section 2251A. Enticement of a minor to engage in sexual activity. 18 U.S.C. Section 2422B. Conspiracy to obstruct justice. 18 U.S.C. Section 1519. 18 U.S.C. Section 371. And conspiracy to receive and receipt of child pornography. 18 U.S.C. Sections 2252A, A2, and B1. I told you when you see these two, that means sections. Just one means section. Okay. The Seventh Circuit has held that a defense based on an inability to form the requisite intent to commit a crime is an extremely limited defense because of its potential to confuse the jury. Right. So this is what I'm saying. They said it doesn't constitute a defense. That doesn't mean that you can't use it as a defense. Now they're saying that because that particular defense is an extremely limited defense because of its potential to confuse the jury. Okay? Which is the truth. but that doesn't mean that it can't be used. And hey, so let's see another case law. Expert testimony is allowed only when it can make a meaningful contribution in guiding jurors in determining whether intent to commit a crime existed. Here, Kelly's illiteracy, academic function, and IQ score will not affect his basic understanding of concepts such as age, what constitutes sexual activity, and what it means to make a recording of sexual conduct. Okay, they got a good point. But the defense can also say, but due to his lack of reasoning, his intellect, he may not know wrong from right. He definitely isn't expected to know the law based on his mental deficiencies. They can come back with that. Okay, let's see. Kelly has failed to demonstrate how Dr. Rutel's testimony would negate intent and not merely present a dangerously confusing theory of defense more akin to justification and excuse. What I told you, y'all, justification and excuse. They are exculpatory defenses. So let me read because we went over that extensively over here. Kelly has failed to demonstrate how Dr. Mattel's testimony would negate intent and not merely present and dangerously confusing theory of defense, more akin to justification and excuse than a legally acceptable theory of lack of mens rea case law. Okay. I guess the 10th Circuit in 2019 stated that the Congress chose to eliminate any form of legal excuse based on psychological impairment that does not come within the carefully tailored definition of insanity in 18 USC section 17(a). So what they're saying right then, that particular um, opinion stated that they think that the mental health thing needs to pretty much align with somebody being declared insane. It says, let's see. Dr. Mattel would thus have to provide a link between Kelly's alleged condition and the likelihood that at the time of the offense, Kelly did not form the intent to commit the crimes with which he has been charged. Well, damn, look like you just gave him a defense. Huh. All right, that's pretty convenient because he can come back and say that at the time of the offense, just what you just said, Kelly did not form the intent to commit the crimes with which he has been charged. He could come back and say he didn't mean to commit those crimes. And based on his mens rea, he didn't even know he was committing the crimes. This is the craziest shit ever. It's the craziest. Cat, what the fuck? Okay, let's see. This Dr. Mattel cannot do. Dr. Mattel examined Kelly in May 2022, multiple decades after much of the charged conduct, and thus none of the resulting findings were specific to Kelly's mental state at the time of the alleged crimes. Kelly's reported IQ score reflects only Kelly's cognitive abilities as of this year. Reference. Evidence offered as psychiatric evidence to negate specific intent is admissible when it focuses on defendant's state of mind at the time of the charged offense. So they are trying to make his claims, his mental deficiencies. They're trying to make him make him deal with the intent of the crime at the time. But do we know? Well, intent is usually something that if they said did knowingly and all of that, if that's in that element, that is speaking to an intent. So the prosecutor might have boxed him in. Please don't let me have to go pull up that motherfucking indictment. I got other things to do, but I don't like to leave no work undone. Please don't let me pull up that indictment. If it's in there saying knowingly and willfully and all that bullshit, then yeah, it's speaking to the intent. So the prosecutor may have boxed him in with this. Well, let's go. It says testimony from psychological experts such as Dr. Martell, in, including the introduction of IQ scores, is often disfavored for exactly these reasons. The case law. It says MD Alabama, I guess, in 2006 stated rejecting the admission of a psychological report as not nearly probative enough to the issue of Lawson's mental state at the time of the offense to warrant consideration by a jury, where report failed to connect low IQ with the intent to commit charged crimes. And then we have case law, and it says it goes on to say, I guess in December 29th, 2015, the battle, I don't know who that is, finding that no legal support for a defendant's admission of expert testimony of the defendant's IQ to establish that defendant is not generally capable of forming the requisite mens rea to commit the crime absent a proper diminished capacity defense. Okay, so the diminished capacity is his mental deficiencies. So what are they trying to say? Hold on. And so they're saying that okay, so isn't it appropriate enough to on the issue of the Lawson's mental state? So they're saying that it doesn't prove, the issue of Lawson's mental state at the time of the offense. So they're trying to make them say, hey, like I just said, when he committed the crime, what was the intent? Now that requires me to go back to see what those elements are. Is it saying knowingly and willfully or anything like that? Okay, so I have to go do that. So I got to do that. Kelly has also failed to show how Dr. Martell's testimony will be helpful to the jury. Kelly has not shown how Dr. Martell's intellectual disabilities testimony will assist the jury in determining, for example, whether Kelly harbored a purpose to produce the videos he is charged with creating in counts 1 through 4, or whether Kelly had knowledge that the videos would be transported to interstate or foreign commerce. So yeah, they're trying to box him in. They're trying to make him stick to the intent when he committed the crimes. And they're saying that this man cannot speak to that. He not cannot speak to it. He is not offering testimony with regards to that, based on what they've seen. Okay. So they're trying to box him in. And they're giving very valid and strong points as to why this testimony should be excluded. Okay. But if the defense say that his testimony is essential to his defense, then that may be something different. Right now, the prosecution is saying this expert witness is no relevancy to the charges. The defense, in my opinion, I don't know how this is going to come back, should be saying, but this is relevant to our defense. However, you got an issue because you didn't include it in the motion in limine in in enough time, because there are timely filing and notification issues. All right, let's go. Okay, let's see. Okay. All right. Kelly has also indicated in other filings that his defense will be that the individuals referenced in the indictment were not minors at the time of his sexual encounters with them. This means apparently that Kelly would not contest that he made the videos or that he interacted with the reference minors, substantially diminishing the need for any expert testimony about the alleged deficits, in Kelly's cognitive abilities. Yeah, they're trying to box him in. Now, that was a strong move right there. They saying you don't need an expert if you're saying, yeah, you made the videos, but the girls weren't minors, which is kind of deceptive because the defense can have multiple strategies, multiple defenses. They're not just limited to the girls were minors, as this as the prosecutor suggests. They're not doing that. So that's a little deceptive because the defense is not saying that they're only pursuing one defense, and that is the girls weren't minors when the videos were made. So that's a little yeah, they trying to box them in real good. This is interesting. And I know you when you look at the titles and you say, "Oh, this ain't this ain't juicy. This ain't juicy as the Larry shit or whatever." But here over here, when we read all of this type of stuff, we're getting a glimpse inside of what the actual case is about, their defenses and all of that. What each side may have on each other and all of that. We can decipher based on what we get. So this tells us a lot about what the fuck is going on, because over here we don't mind our own business all the time. Let's go. It says Kelly's notice is also deficient because he has not established the reliability of Dr. Martell's testimony. The government has not received from Kelly a copy of Dr. Martell's report, and the Rule 16 notice provided scant information about Dr. Martell's testimony. Rule 702 requires that testimony from an expert be reliable, and without this showing, Dr. Mattel's testimony should be allowed to proceed. I think I made a mistake. It's the Rule 16 notice of the um, timely filing for pretrial motions. Sorry, not the Rule 12. It said, hold on, let me make sure. I don't know that shit. I don't Nobody knows that shit off the top of their head. Yeah. Hold on. Yeah. Hold on. Okay, wait a minute. No, it is Rule 12. I'm sorry. It is Rule 12. Before I even type it in. No, it's not. It's Rule 16. Okay. Hold on. Yeah, it's Rule 12. I was right the first time. It's Rule 12. Never mind. Never mind. Okay. Let's see. Okay. Rule 702 requires that the testimony from an expert be reliable, and without this showing, Dr. Martell's testimony should be not allowed to proceed. Finally, even if Kelly satisfied Rule 702's requirement, Dr. Martell's testimony should be precluded under Rule 403 of the Federal Rules of Evidence because the testimony will be unduly confusing and prejudicial. Even evidence that a defendant's logical thinking was impaired is the type of testimony that would likely confuse the jury. Case law. It says in the, I guess, Northern District of Illinois in 1985 stated rejecting expert testimony regarding defendant's mental state as it would not assist the jurors in determining the defendant's intent and would tend to confuse jurors regarding the defendant's poor judgment. Testimony speaking to Kelly's poor judgment or inability to think clearly based on below average cognitive abilities would likewise serve to distract the jury from properly considering his intent to commit each alleged crime. The potential for confusion is compounded by the fact that Dr. Martell's proposed testimony at trial would not even address Kelly's mental state at the time of the alleged crime. See, I told you, they trying to get him to stick to just on, what was your mentality, what was your mens rea at the time of the alleged crime, right? And that has something to do with the intent. So we're gonna go back and see if a language in there refers to intent. B. The government requests an opportunity to examine Kelly if Dr. Mattel's testimony is allowed. Should the court permit Dr. Mattel to testify on Kelly's behalf, the government requests time to conduct its own examination of Kelly pursuant to Federal Rules of Criminal Procedure 12.2 C1B to determine Kelly's mental capacity. If the defendant provides notice under Rule 12.2b, the court may, upon the government's motion, order the defendant to be examined under procedures ordered by the court. This examination is necessary to assess Dr. Martell's conclusion. For the foregoing reasons, the United States respectfully requests that the court exclude Dr. Mattel's testimony at trial. Should the court allow Dr. Mattel's testimony to proceed at trial, the government moves to conduct an examination defendant pursuant to Federal Rules of Criminal Procedure 12.2 C1B. So there are some footnotes, and I need to read these. Okay, one, on July 21st, 2022, Kelly sent the government multiple expert reports along with the cover letter stating that the defendant may call the following witnesses at trial: Steve Klein, CBT, Dr. Daniel Martell, Dr. Renee Sorrentino, and Dr. Park Dietz. I think most of those were the people that worked on the New York mitigation report for R. Kelly. The only witness included on the witness list that Kelly submitted to the court on August the 4th, 2022 was Dr. Daniel Martell. Kelly's counsel later added Steve Klein to the witness list on August 9th, 2022. This motion is confined to arguments related to Dr. Martell, and the government assumes that Kelly is not calling Dr. Sorrentino or Dr. Dietz to testify. 2. Kelly Rule 16 letter is deficient in that it does not provide the witness's opinion, the basis and reasons for those opinions, and the witness's qualifications. Federal Rules of Criminal Procedure 16B1C. All right, number 3. Emblematic of this, Dr. Martell's expert report was initially prepared as part of Kelly's sentencing mitigation package following his September 27, 2021 conviction on charges in the Eastern District of New York, which is what I said. Okay. Okay. Facts presented in mitigation and sentencing are ill-suited to determining guilt or innocence, rendering them inappropriate for the present stage of proceedings. Reference. It says the Seventh Circuit in 2002 stated that comparing the largely objective guilt phase of trial with evidence in mitigation, which often consists of testimony about what damaging forces a defendant has endured in his life or what kind of a person he otherwise is. Okay, so I gotta take this down real quick. I gotta pull up that goddamn indictment. Hold on. and I come around the front. Y'all bear with me. My phone is blowing the hell up. Hold on. Oh yeah. All right. So let me see. Robert count one. Brenda. Okay. All right. So we got did knowingly employ. So we got some did some knowingly in his charges. So I just pulled that up. Knowingly. So they're talking that speaks to his intent. The prosecutor is pinning it to the intent. So I see where they're trying to go with it. That is in the indictment. Come back around the front. What's good with it? What's good with it? Molly? Some more people. Hey, the hell. Hey, Shaniqua. Shout, hey. Hey, Tisha Lee. Hey, Chicago, Chicago. Hey, Valencia. Hey, Valencia. Hey, hon. Hey, Mo. They got me working today, baby. Hey, Karen. Make sure you like us up. Hey, my Queen K. Purple, purple. Hey, Danny. Hello, Danny. Hello, Danny. Oh, Lord. Y'all getting a little bit of first shift today. Oh, Lord, the hill in here slaying, swinging and banging. Hey, Phoenix. Phoenix came back. Hey, Mama Phoenix. Hey, my Phoenix. Rising. I don't know what happened to that call, honey. I don't know what happened to me at the end of that goddamn live. I was gone. Hey, Candy. It's like candy. Ow. 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 Can you feel it? Hey, Leslie. I said, hey, Leslie, the welcoming committee. Leslie Jennings on the welcoming committee. Yes. Did it respond to unsealed motion? Hold on, let me see. Okay, I don't get in the chat business. Let me get to the questions that's posed to me. Did they respond to the unsealed motion that JPO filed unsealed and then government asked to unseal it? And that's why, and you know what, Red Bunny, that's why I hate how this Chicago shit is going with this paperwork. You got to open everything because they're not putting it in, you know, precise like they did in New York. And we got a judge that handles 50 things at one time. He'll handle 50 things on the call, 50 things on briefs when he send it in, 50 things on oral, you know, his oral orders and all of that. Ugh, just 1 minute. I'm sorry, y'all. I'm sorry, y'all. You know what? I couldn't tell y'all that I'm working and doing something. I just went right to working. My bad. I got a lot going on, baby. Ooh, woo. People want to try me. People want to try me. See, I get hired to solve some of those, little pesky goddamn legal goddamn issues and shit. But they know I get on your ass. Not finna have a debate back and forth. Not finna do that. And I'm hot. Shit. They don't understand. When black people get hot, they lose their goddamn mind. That's why all those crazy ass crimes occur in Florida and Texas. Because it's too hot. So, oh, let me drop the link. So I hope y'all understand what I was saying. Y'all see how the prosecution is trying to treat that particular motion. They're trying to make the defense gear that whole mental deficiency defense to his intent when when the alleged crimes were committed. They're using, you know, they're using some statutes and shit to support their response, right? They're also saying that it's not timely. So they have a lot of, a lot of things that but I do remember, and I'm pinning the link. I do remember. I think it was that last bootleg ass order with regards to that motion in limine that the judge put out. And I don't know if y'all can remember that they did say they wasn't using mental deficiencies as a defense. I'm trying to see was it on that. Shout out to the whispers in the building and the whispers that's not. I'm getting your messages. What is it? Hold on. Hey, did that other company call you about that work? Who you talked to? No, the other one you said that you got a response from, and the about you met one that from Advantage, from the Advantage. Not the first name you gave me. No, that's two different. Okay, well, what the text message say? What list? Give me the list of the companies that the text message say. Okay, so that was just the one company. That's not a combination of companies. Oh, okay. Well, those two companies are the same. When was that interview? But I thought you had one with the other people. Well, you just had so you had two already. Oh, well, you didn't tell me about the second one. What happened with the second one? Oh, that's the one where they want you to go all over the planet. Oh, okay, okay, okay. All right, push those products. Okay, all right, not a problem. All right, but just but you have to give my name when you you know what I'm saying. All right, bye. All right. I dropped the link. Huh? What the hell? Some kind of chameleon shit is in the background. What? You talking about me? The fuck you talking about the hell? To Esther Lemingo, the feds are corrupt. They need criminal for frame a man. This is about the ratings, not this woman. This was never a federal case. It's funny how they protected Epstein. Okay. So, well, listen. Oh, you talking about that with you? Okay, but listen, y'all. So they getting down to the nitty gritty. They are trying to okay on that order with that motion to limit. The judge, granted some stuff. Okay, you can look at that. It's getting motions passed, even though it was a combined as motion limited. They got some stuff granted. Okay, so you can look at that as a good thing if you are on Team Chaos. Now, if you're on Team Chaos, lock him up. You still sit in a pretty position because one, y'all brought the case, y'all have the evidence and all the pieces that y'all need to convict a motherfucker. And let's see, right now, though, let me tell you something. Right now, I'm telling you why it's evil. I hate to change the course a little bit. Because right now, the defense is simultaneously doing a whole bunch of things, a whole bunch, deploying a bunch of strategies to try to get a W out of this situation. They playing it up for the media, like already casting doubt on this whole proceeding. They are they're going back and forth with the prosecution with different matters, you know, trying to get their defenses in, maybe on the slick. So they swinging and banging. They are swinging and banging. Prosecution again, of course, they got the edge, they got the nod because they have the case. They allegedly have the evidence. They are applying every rule to box them in. Every rule they can think of. Okay? They are raising timely issues and all of that. The judge is in a unique position because he doesn't want to deny something that could possibly come back to haunt him. Right? Now we already know with all of the with I believe, like, based on some of those motions that they were putting out with regards to the unethical practices and all this whatever. I already know that that's if there's a conviction in this case, that's going to go and sit. I mean, they're setting up their appeal early in the game, and that, they can parlay that into a uh, a issue, right? So they're getting down. That defense is getting down. They're making, they are making a collective effort and a very strong stride to get, these people off. But of course, the prosecution hold the cards. It's kind of hard. The defense is fighting to get their defenses in, fighting to get parts of the prosecution case prohibited, or excluded, should I say? But I don't want to say excluded because that would be talking about the evidence and stuff. Well, that's pretty much what I'm talking about. But so it's almost like playing chess. Now I've never played chess, but I've seen it play. You move here, they move there. You do this, they do that. Yeah, so this would be the hell. I wish you could too, because your ass would have something to say. So this is the craziest shit ever, ever, and they got us busy. They got our ass busy as hell, honey. They everybody talking about that goddamn pacer bill. Let me tell you something. And I know I pull a lot of motherfucking bullshit. Y'all see me do it. But I was able to decrease my paper bill from $400 down to it was $150 I believe. Yeah, $150. And I told you I did that by once I pull the document, I save it. Instead of going back and re-pulling it over and over again. I did not know that they were charging us to keep doing that. So and I know we pull pacer. A lot of us will pacer a lot, you know. I don't know what the fuck's going on. But y'all, mm, and again, I am all for everybody on any side getting their goddamn story out. I don't interrupt people. I let them say what they gotta say. That's not me encouraging shit. That's not me allowing shit to go down or whatever. That's me being a goddamn person who knows that you got to let people say what the hell they want to say. As long as they talking about his mamas and wives and kids and shit. But say what the hell they want to say. Have nothing to do with me. And kind of respect their wishes, right? I add that in. If a person tell me they don't want to talk to a certain person, engage or whatever, that's fine. That's not what we're gonna do. They'll just take turns going back and forth. And shout out to the people that respected that. You know, you still get whatever you got to say off, and it's better for us because we can hear you. Because if both of you up here at the same time, all we hear is back and forth, back and forth. Everybody talking over each other and screaming. So shout, shout outs for the people that being tolerable over here, understanding and still participate. So shout outs to all of that. Hey, Indiana's finest. What's that, Danny? Hold on. Let me see what you got. Let me go out there and grab it. All right, let me see what that is. Where did it come up? Okay. The court listener. Right. Yeah, that's why. Yeah. I go straight to Pacer, but I am hooked up with court listening because it gives the notifications. Yeah, that's what I just read. Document number 264. Thank you, Danny. Let me see. Silver US. Silver USA. I read that already. Mhm. So we have to, and let me look at that motion with regards to this Larry shoe. I need to point something out. I just want to make sure when I point it out, and I'm correct. Okay. Okay. Hold on. A defendant's agent. Let me put this up here so y'all can see. Oh, well, I know that you can get some of these documents free from court listener because that was, it just let me pull it up. Thank you, Danny, for that. So, let me tell you what I'm looking at. Okay. Okay. Relating fraud to visit communication agents from the Department of Justice. Okay, so there was an investigation. This Larry shit. Okay, there was an investigation from the agents from the Department of Justice, Office of the Inspector General. OIG began to investigate and search the internet. Began investigating and search the internet to obtain further information about what Tasha K disseminated on YouTube and to other social media platforms. Uh, and OIG learned that between seven. Okay. So there was an investigation. Okay. Okay. BLP address. So Kelvin, I requested for government to disclose him specifically if no OIG separate investigation. This information, however, is sensitive and unrelated to the instant case. The requested information includes the following: personal file, BLP. Oh, okay. Well, listen to this. Listen to this. Kelly now requests this court to order the government to disclose to him specified information from the OIG's separate investigation. And know this, when they say Kelly, they don't mean, they have to say Kelly because he is in charge of his own defense. Okay? This doesn't mean that he's doing all this type of shit. That this I seen some comments or whatever, and they were saying like R. Kelly is requesting all this whatever. Legally put, he is, but this is the attorneys that he's hired to speak for him, so they go forth under the guise of R. Kelly, right? All right. Okay, it says, let me start over. It says, Kelly now requests this court to order the government to disclose to him specified information from the OIG's separate investigation. This information, however, is sensitive and unrelated to the instant case. The requested information includes the following. Okay. So Kelly maintains that without support that all material OIG collected during the investigation, Kelly constitutes grave material. Kelly does not cite a single case. So, but then the information is relevant to the allegation of the issues with their sexual abuse of minor girls. So that's the part I try to highlight. Oh, so let me tell you this. And this is not meant to turn shit upside down and act like a damn fool. Because I still stand on what I say. I'm just repeating what they said. Because what this type really means, this whole part I just read, from here on going forward, it means that the prosecution has determined that with regards to the following, the officer's personnel file, the BOP True View system, and all of that, they really don't think they should turn that over because it's not relevant, relatable, reliable to his charges. It's not discoverable. It has nothing to do with the case. Now that's now the defense may come back and say, "Oh, because look how they put emphasis on the word all." It says Kelly claims without support that all the materials OIG collected during this investigation likely constitutes a Brady information. Kelly does not, and they highlight the word all, which tells you right there that they are opposed to giving up this information. And they go on to say that Kelly does not cite a single supporting case. It does not mean that they did not clear Larry, because as you clearly say, read on, they go into the Larry issue. But they are saying that what the parts of the investigation that involve this stuff, they don't think that the defense should have. So I'm pretty sure, you know, J Bo may jump on that. I don't know. I would if I was a defense. Just saying. Because that plays a part of my strategy. Okay. Kelly argues that he is entitled to OIG investigative materials because the information that Tasha K disclosed about him was apparently shared with a supposed government operator named Larry McGee. The government has a duty to disclose any information in its possession that's favorable to the defense and materials either to guilt or punishment. The information favorable to the defense includes evidence which would tend to exculpate the defendant or reduce the penalty, and the evidence regarding the reliability or credibility of the government witness. But here, Kelly's speculative and deficient claims do not fall within these parameters. Kelly claims that the individual Larry McGee received Kelly's visitation list, phone calls, or emails with his girlfriend. But this is pure conjecture, meaning it's just speculation. Kelly fails to provide any confirmation of when or how Mr. McGee received any of Kelly's information or what specific information Mr. McGee allegedly received. Moreover, even if McGee had received such material, Kelly fails to articulate how Kelly's visitation list, phone calls constitutes Brady material that would tend to exculpate him. But in any event, Kelly knows who visited him and was okay, so they go into all of that. So they are making an argument here. I don't know if the defense is going to lay down on this and let it stop here. While this basically does say that Larry did not receive anything that would be material to that R. Kelly case or cases, would have nothing to do with the issues, the elements, crimes, however you want to put it. But it does appear that there was an investigation. They uncovered what they needed to uncover. It seems like they are reluctant to share that some of that information with J Bo. So let me backtrack a little bit with what I said last night. They're going to share what would be discoverable because they have to do that. But disclose the entire investigation seems like they have some type of trepidation with regards to that. I don't know if J Bo or whoever put this in will seize on that. All right, but it did clear Larry right there. Mr. McGee has not before and is not now cooperating in the instant case. Right, Mr. McGee will not be called by the government as a witness in this case. Okay, the government has not interviewed him, in connection with this case. The prosecution team in the instant case is not privy to whatever corporation. Oh, wait a minute. Hold on. Hold on. Hold on. They're saying that Larry would not be called and he have nothing to do in this case. The prosecution team in the instant case is not privy to whatever cooperation Mr. McGee has provided in other federal cases in other districts. Illinois is speaking for Illinois. Huh. But overall, whether it be Illinois or New York, whatever was the results of the investigation, and it was discovered that Tasha K got hold of visitation logs or whatever, this, that, and the third, it still has no bearing to the case. And Larry got, nothing to do with all of that. Even if he got some visitation logs or whatever and gave it to Azrael, I'm just saying hypothetically, that would not influence the case. You know what I'm saying? It has nothing to do with the elements, the charges, none of that. It still wouldn't. Whatever Tasha K got, we know she got something. It still wouldn't have nothing to do with the charges, according to this, because it had something to do with the visitation logs and all of that. Jabo and them in her filing with regards to this, in her motion, she asserted, she said that it maybe client privilege, all of that type of stuff with what Skylife was saying, whatever Jabo said in the motion. But see, that was speculative. Like they said, she did not provide any evidence with regards to that. So she don't know. And apparently the investigation did not uncover any type of client privilege situation, in violation. You know what I'm saying? Information that violated that privilege. So I'm going through this is carefully written for a reason. See, I was sleepy last night, but I'm catching some shit. Okay, see, the screenshot Kelly includes in his motion from what appears to be a social media site does not establish that Mr. McGee cooperated in the instant case, meaning Illinois. The screenshot shows a January 2020 email exchange. Mr. McGee emailed AUSA Angel Crow a message which the screenshot does not contain. And Ms. Crow responded, "Thank you for sending this." The screenshot includes entries from the Grown Man Show. The government is aware of the emails from the sender, the Grown Man Show, in Kelly's screenshot. The email is unsolicited message regarding material that is not relevant nor at the issue in this case. So, saying that the email was unsolicited, meaning they're trying to cover Angel Crow, saying that Angel Crow didn't ask for this information, that Larry sent it to her anyway, but it's not relevant, nor is it an issue in the case, right? Meaning it has nothing to do with the charges. Specifically, in the email, the sender posts screenshots of posts from a Kelly supporter's blog discussing how others can support Kelly on social media. email exchange does not establish that Mr. McGee provided substantive information to the prosecution team. Kelly makes vague references in his motion to Officer A, influencing witness testimony. But Kelly does not identify how, where, when, or what government witness in this case Officer A allegedly influenced. Officer A is not a witness in this case. So that's telling you right there that that motion that J. Bo submitted was all speculative. All speculative. Well, let me cut you off. So remember, I told you those motions, as well as this one, was all alleged. Kelly misstates in his motion that the contents of the affidavit submitted in support of the search warrant for Officer A. Bill P. computer. For example, Kelly is reportedly quoting the affidavit states in his motion that the OIG investigation was open to investigate the potential crimes of bribery, fraud, theft, narcotics trafficking, money laundering, ethics violations, and other official misconduct. Or the affidavit language Kelly references is in the section describing the affiant's training and experience about those type of cases he investigates, and not the crime under investigation by the OIG. Oh wow, that's big. Not big as far as this the case. It's big as to saying that that was a big mistake, because if she was referencing potential crimes of bribery, fraud, thefts, narcotics, and trafficking, money laundering, ethics violation, other official misconduct, that was a representation spoken from the affiance, which is the person, whoever they were referring to, experience, whoever put the paper in that had that verbiage in there, that swore to it. That's what an affiant is. So it must be somebody worked for the government. They was talking about his training, and not saying, she kind of said that it was crimes that was regard to this case. No, that was his background and his training. So that was a big fumble right there. That was a big fumble. Like you misrepresenting what was said. That man lists those. He apparently has training or work with cases with regards to bribery, fraud, theft, narcotics trafficking, money laundering, ethics violation, and other official misconduct. I guess how she wrote it up, she was saying that those things are in relation to this case. Wow, that's crazy. Kelly also states that in his motion that the investigation revealed that Officer A sold information to Tasha K. The affidavit, however, does not conclude, let alone mention, that Officer A sold anything to anyone. Wow. So that's made up. Oh, wow. I'm glad I went back over this. Let me come on around the front. Don't kill me. Wow, that's crazy. So I definitely hope that was used as a big part of the strategy to show that the prosecution perhaps have some ethics issues. And maybe, because they called down a lot of stuff. Mm. So you see how those filings can be just chocked full of speculation. Your perspective, like I told you, they're trying to persuade either the other side or the judge, depending on if it's a motion, trying to persuade the judge. If it's a pleading, trying to persuade the other side, or asking the other side to do something. Wow. Um. So piece in the puzzle, that just pretty much means that Jay, the defense was. I think this is my opinion. I told you this is my opinion. I think this is a part of a strategy to make the prosecution look bad. Whether the information was verified or not, whether it's true or not, they can write a brief from their perspective, not an offer up or shred of evidence, and it is what it is. So I'm pretty sure that well, the, since nothing really nothing really damaging came from the investigation, maybe that somebody, maybe at the BOP or whatever, some of those people maybe should get locked up or whatever, maybe. Other than that, I don't see what harm is that the judge won't compel the prosecution to turn over that information. But insert with I guess with regards to certain information, the prosecution have some hesitation because what they're saying is that information contains sensitive information that has no bearings on the case. So I don't know how Leonard Webber going to rule on that, because if the prosecution is saying the evidence that they uncovered from the investigation isn't relevant, reliable, relatable, then why should they turn it over? It's not discoverable. It has nothing to do with the case. So don't know about that one, kiddos. That man, that judge, he getting a lot of shit put on his desk. He really is. But y'all, I'm finna go and push on up out of here. I really am. I'm finna go and push it on up out of here, honey. Maybe I would hook up that old bootleg ass portable air conditioner that I promised you when I used it before. It did nothing but get on my goddamn nerve. Cause I had to keep putting, got to put water in it and shit. I ain't with all that. Trying to find a man with the damn uh wasn't, and it's hard to get. Now I'm trying to find somebody else to come out here, and I got to start the process all over again. Come out here and see what's wrong with it, order it, and install it. That's like two different visits and a bunch of shit along the way. Right, it wouldn't have anything to do with the case. You know, they can try to use it externally to cast doubt, like I said, as a strategy. But other than that, I have nothing to do with this case. What are you talking about, MacDime? MacDime, Y'all with these conspiracies and these delusions and paranoia. Everybody ain't out to get you and do harm. But you got to prepare like they are. Don't get me wrong. I ain't said be no fool. But everybody ain't out to get you. She could use it as to show examples of how, if she goes like as far as something with regards to rights, violation of his rights. But and prosecutorial misconduct, that would be the big one. But we don't see, per the investigation, we don't see any prosecutorial misconduct. So, mm, but anyway, let me push on out because hey, your girl is busy. And I bet you when I fired off that last motherfucking response. Oh, thank you, Peace in the Puzzle. Thank you. I'm glad I went over that a little bit more. Illinois is talking about the instant case, their case. So, anyway, let me push on out. I will holler at y'all later. Make sure y'all hit the like button, share, and subscribe. Peace out. Me love you. And you know what I got to pray for? I got to pray to get for the Lord to give me the heart for forgiveness. Ooh, baby, I don't do that. Mm-mm. No, ma'am. I don't do that. Because I figure you shouldn't have been fucking with me, doing stuff to me in the goddamn way. Hell. But I got to get to that. All right, y'all. Let me get out of here. Thank you. Curly your wig and don't. Okay, let me get out of here. Bye, y'all.